Welcome to Law 2022 Online, Residential Property Spring, Shape the Debate, hosted by myself, Mike Giorgio from Move Reports. In this live session, you can put your questions to our experts, Richard Snape and David Keeley, and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. So the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you are watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be available on the website within the next few days. So myself, I have been in the search business for 22 years, since July 2000. Originally owning and operating the PSG franchise for North London, and for the past 8 years as the Regional Director for the South for Move Reports. I have helped develop processes and software replicated and used by many today, and have been involved at government meetings in the development of HIPs at the time. Today, without the constraints of a corporate company and being truly independent, I help develop bespoke and unique tools and offerings for conveyancers. We help our clients secure their work against the competition by following two mantras that are the ethos of our company. Firstly, others say they are different, we know we are. And secondly, if you don't get the work, we don't get the searches. Well, that's a bit about myself. Richard. Richard has been the head of professional support for Davitt Jones Board since 2002. He was formerly a senior lecturer in law and head of land law at the University of West England, Bristol. He speaks at numerous courses for law societies all over the country, various public courses, in-house seminars within solicitors' firms, and has also talked extensively to local authorities and central government bodies. His area of specialism include both commercial and residential property, particularly in relation to local government law, conveyancing issues, development land, commercial property, and encumbrances in relation to land. As part of Law 2022 Online, Richard's session will include building regulations, easements, the characteristics and issues affecting these. David was admitted as a solicitor in 1982. Until his retirement from full-time practice, he was a partner and head of residential property at a Legal 500 firm. He now uses his extensive experience and understanding of practical conveyancing to cut through the academic niceties and make things relevant for the busy practitioner. He is a contributing editor to the Law Society Conveyancing Handbook. As part of Law 2022 Online, David's sessions will include residential property practice updates, listed buildings, conveyancing points to consider. So to commence the session, we'll be addressing some of the pre-submitted questions we have been receiving from you, and please do add them in the chat box. But before we start, Richard wanted a quick word with you.
Yeah, it's something that's happened within the last few days. It's in the my building regulations notes, and it refers to the Building Safety Bill. Building Safety Bill passed through Parliament last Tuesday on April 26th. It received the Royal Assent on April 28th, so it's now the Building Safety Act. And it's not enforced yet. Some provisions are expected to come into force within the next year. Other provisions won't be coming into force for, they say, up to 18 months, and now a year to 18 months. The major changes, it's actually underwent quite a lot of changes in the last month or two. The major changes, reference to the notes, is you've got a reference for a building safety manager who will be appointed in high-rise residential buildings to deal with the safety of the building. Will be appointed by principal accountable person. They've dropped the concept of the building safety manager. And the other thing that's changed massively, and it is a big change, I think it's probably highlighted it was going to have to change, is they refer to a building safety charge. The cost of the manager and any work that needed to be done in relation to building safety will be added to the long leaseholders. Even if not covered by service charge. That's not the case anymore. It's got to be covered by service charge. And we've introduced caps on service charge liability in relation to defects. For instance, if your property is valued at £175,000 or less, or 320,000 or less in London, you won't be able to add the cost at all to service charges. And there's also caps, £10,000, £15,000 for defects, relevant defects, £15,000 in London. So there are quite a few changes to it. Keep your eyes open on the enforcement period. That's my little bit.
That's your little bit. Okay. Well, the first question is actually for you, Richard. Can you clarify the enforcement periods for breaches of building regulations, as you mentioned, both 1 year and 2 years?
Yeah, there's a lot of myths about it. I mean, the enforcement periods from the local authority in relation, the basic enforcement period is a year. And they can take enforcement action against, the people who, property owners at the time, but also subsequent purchasers. So if you're acting for a purchaser, that's the important time period. They can actually prosecute for up to 2 years, but the people who get prosecuted are the builders and the likes, the people who actually do the defects, and it's very rare to prosecute. There is a possibility that they could get an injunction in relation to dangerous building material, building work and the likes, or lack of building regulations. Again, that's pretty rare. The local authorities unfortunately tend not to find out until the breach has actually occurred. There is provision in the Building Safety Act. There is a regulation, possibility of a regulation, whereby we're going to increase the time period for enforcement for 10 years. And if that actually happens, it'll change your jobs. So keep your eyes open on that. The other thing that the Building Safety Act is finally implementing something called Section 38 of the Building Act 1984, which never came into force, whereby anybody who suffers losses with the consequence of defective building work in relation to building regulations breaches can sue for their loss as well. So that's about it. I don't know if David's got anything to add to that. Or...
No, I think you covered it pretty much. As I agreed with Richard. It's rare. I don't think I've ever. Well, I have. To be fair, I've come across one instance of a local authority prosecuting a breach outside of the time limits, but that was Fareham Borough Council. But it's and that was rather bizarrely, it was a builder who did his own house, and he did such a bad job on it that the local authority sought an injunction against himself, but which can't have been very good for his future business prospects. But yeah, people do get very worked up about it. And I mean, the 1 year rule is quite clearly there in Section 36.
Yeah,
and yeah, there's a number of requests I get still in when I do my locum work for people wanting indemnity policies for things that were done 20 years ago. Is well, laughable, shall we say? But
I came across one where it was clearly a 1920s extension, and they wanted building regs and planning permission. They capitulated on planning permission when you explained that it predated planning permission by about 25 years. But they still wanted building regs, and it's one of those things that's so unfortunate. You know, it's just wasting a lot of fear and the time when you reach for a policy, unfortunately. Well,
yeah, I think I did say to one firm I refused to make a donation to the Underwriters Beer Fund, because that's basically all it was going to be. It was a complete waste of time. Yeah, the 1 year, and people do still hang on about that the case, saying that they can take injunction proceedings outside of the 1 year period, but it's vanishingly rare, isn't it? But
well, they don't find out. They haven't got the resources to find out. If they thought the building was a death trap, they'd take action.
Yeah, indeed. I think the answer probably is if somebody wants it, say, well, can you show me where in your survey it says that this is a dangerous structure? I
suppose the other thing to mention, probably going into other areas now, is that what your client also needs to know if there's building regs breaches is that by all means pay for a policy, but refer it to the relevant expert. Structural engineer or surveyor or whatever.
So the policy won't cover you against any defects, just the unlikely event of the local authority taking the enforcement action. So it's I'm not sure they're worth the paper they're written on, to be honest.
Okay, so the next question's for you, David. Does the Law Society note EWS1 mean that I do not have to reply to inquiries about EWS1 issues?
Okay, I suppose the point being made here is the guidance note which the Law Society have issued, aimed at not at us as practitioners, but at clients, making clients aware that solicitors are not able to advise on structural issues and are not able to take responsibility for whether or not an EWS1 is required. I think the point is it depends on the question. If you get a question which is there an EWS1, then that's a straight factual question. So the answer is, answer it because it's a yes or no. If, however, the question is perhaps phrased as please supply an EWS1, or if there isn't one, please provide evidence that one is not required. Now that is obviously straying outside of the responsibility of solicitors. And effectively that should be rejected and say, well, there isn't an EWS1, and it's up to you to take your client to take advice from a surveyor about whether one is required. So it's a question of degrees, isn't it? I mean, yes, you don't have to answer questions about structure. You don't have to answer questions about the nature of the works, but you do have to answer factual questions. So yeah, it's a question of degree, I suppose. The point I think I made in the talk about the Law Society guidance note is it's really emphasising to clients that we cannot take these decisions for them. It's up to them and to take advice from surveyors about whether or not the building is structurally safe or sound. That's not for the likes of Richard or I or other practitioners to advise on.
Okay. Still on EWS1s, this one's for you, Richard. What is the latest on EWS1 certificates?
Well, obviously, David's mentioned a bit about it. There's so many myths and misconceptions going on, and truth be known that these external wall system certificates, they've been a disaster ever since they were introduced. You can understand why they were introduced. The latest, I suppose, is going back a few months, just before Christmas, on December the 10th, the Royal Institution of Chartered Surveyors, they'd looked at their guidance as to when these things were needed, and as David mentioned, it's sort of surveyors come valuers who should be dealing that side of thing. And they basically said that they still think they're required. Nothing's changed. January the 10th, the Department of Levelling Up Housing of Communities. I hate that. But when you Southerners have to give me your money. But they, that's you, Mike. But they withdrew the thing that had caused the real problems, this January 2020 guidance, which had said that you might need the EWS1s for less than 18-metre high buildings. And I started seeing people requiring them for 3- or 4-storey brick facaded buildings and the like. RICS then got back. They've changed the actual nature of the EWS1 certificates, but they just they're basically saying that we still need them. I suppose the good news is that if you've got 2018 building regs or 2019 building regs in Wales, the guidance makes clear that you don't need an EWS1 certificate if you comply with the building regs. And a lot of the mortgage companies are getting together now, especially in relation to the lower height buildings, and they're also saying there's Fire Safety Act of 2021, which is in force in Wales now, but not in England. But if you have a fire safety assessment which complies with the new 2021 Act, and you've carried out any works required, then they might not require EWS1 certificates in the future. So we'll have to see. I think they're a long, long time to go.
Yeah, indeed. I mean, I agree. Richard made the point that the RICS, before that committee, said that they were still needed. There was also mortgage, CML, or whatever they call themselves now. They were at that same meeting, and they made the point that for mortgage lenders, they consider it to be a matter of valuation and finance, because they don't want to lend to somebody who can't then afford to carry out works which subsequently need to be done. So the mortgage lenders are saying that they want them as a matter of valuation and affordability check. So yeah, clearly they're not going to go away anytime soon.
It's just whether they get a bit, there's sort of the 3 or 4 story buildings and the likes, because they mortgagees were saying that we were not going to change anything unless the government withdraws its 2020 guidance, which it did in January.
It did in January. There has been a 4 or 5 lenders have recently made some moves towards standardising their systems, but it's early days on that yet, I think.
But I think there's a lot of myths floating about, and when you see, because it's been in the media. And there's a lot of people who seem to be under the impression that it's some kind of statutory provision. It isn't. If the valuer tells the mortgage company, we need one of these before we can value, and the mortgagee won't back down, that's it. Yeah,
that's it. Yeah. And I think that's what the standardisation they're trying to do, is to try and give standardised directions to valuers as to when they will and when they won't require an EWS1. But yeah, as you say, it's a mess that's not going away anytime soon, unfortunately.
I think they should have scrapped them, quite honestly, started anew. I talked to a lot of surveyors about it, and they're not happy about them.
No, indeed. So, no, initially the thing said buildings of 2 or more stories. So you're looking at sort of blocks of maisonettes. Yeah. Anyway.
Yeah, and sort of brick facade buildings, because there could be combustible cladding behind the brickwork.
Yeah, I did have one where down here in Cornwall, which was an 18th century granite construction, which had been converted into flats, and they wanted an EWS1 for that. So I suggested that if you could try and set fire to a piece of granite, you're more than welcome. But
the radon gas will get you before that.
Oh, indeed, yeah. Oh, that's the other one. Yep. Who supplies the radon gas? Where's the radon gas meter? Yeah, that's right.
Yeah.
Okay, on that note, David, this one's for you.
Actually, there's another one. I think there's one come up on there saying RCIS before number 4. Have you not seen that?
I have number 4 is no. The next one I have here is it compulsory for me to follow the SRA guidance note on leases?
Well, frankly, yes. It's the SRA have issued this guidance note about advising on leases, and they're saying that they're interpreting it as part of their competence requirements. So we're required by the code to give competent advice, and the SRA have put some flesh on the bones to say that they think that in order to be giving competent advice on leases, we need to make sure that we cover in sufficient detail and don't assume that the clients know and understand what it is that they're taking on. So, for example, one of the comments made in the note is that they regard it as not meeting your required standards by just simply saying to the client, "Here's the lease. All the clauses are standard. Read it and let us know if you've got any problems." That they're basically making it quite clear is falling below the required standards of competence. So essentially, yes, you do have to follow the guidance and look closely at your issues and how you advise clients on leases, and in particular the ground rent issues. That's another issue which is cropping up increasingly. Although we've got obviously the June, the new legislation comes in to ban effectively ground rents on leases going forward, but that's not retrospective. So all the existing problems with ground rents are not going to go away. But I think the SRA have that where they've obviously gathered this evidence from somewhere, saying that they've got evidence that people didn't realise they were buying leasehold properties. Well, I mean, I suspect in many cases those people will have had reports which have told them it's leasehold, but being cynical in my old age, they may not have read them, or the dog ate it on when it arrived in their letterbox. But essentially, yes, I think it is a case of read the note, think about what your practice is, and adjust accordingly. And the important thing is that the SRA also make it clear that they will come down hard on firms that haven't trained their staff sufficiently to recognise the problems on leases and to advise properly on leases. So, one way of doing that, of course, is to listen to me or Richard on leases, because that's highly recommended.
That's it. Yeah, and Phil, I mean, there are people who bring in actions against solicitors and conveyancing practices, claiming that they were never told it was a lease in the first place. And I just find that very difficult to believe.
Yeah, indeed.
But I remember a few years back, when the ground rent problems, when we started becoming aware of them, solicitors telling clients that the ground rent doubles every 10 years. It starts at £250 per annum and doubles for the next 150 years. In the last 10 years, you'll be paying over £4 million per annum. And clients were just saying, get on with it.
Yeah.
And they're probably amongst the same people now who are bringing actions against the left, right, and centre.
Yep, I mean, I think when talking about similar issues with another firm, suggested to them that the one way to cover that is to insist that clients sign a copy of your report and return it, confirming that they've read it and have taken note of its comments, so that when they subsequently come back and say, "You didn't tell me," well, sorry, yes, I did, and there's your signature to prove that you knew about it. Mm-hmm. I mean, we've all heard tales of this. I mean, I talking to a firm once before who were being sued by a client for loss of value of his house because they hadn't told him that Crawley was near to Gatwick Airport. So I think we just decided that there are some people that are too stupid to be allowed to own houses. But essentially,
I came across one where they couldn't move, and they complaining about their conveyancer. They weren't able to move because they assumed the conveyancer would book a removal van.
Isn't that the least they could do?
Yes, that you have to in the future. But don't book the removal van, get them to do that.
Okay.
You do wonder how someone managed to be in a position to buy a property in the first place.
Moving on, one for you, Richard. Do we know when the building safety bill is coming into force?
I think we probably sort of discussed that already. We don't know when it's received the royal assent last Thursday, but we don't know when it's coming into force yet. They were originally, I mean, it's a huge piece of legislation, and a lot of it has got that sort of marginal bearing in everyday conveyancing, quite honestly. Some provisions they were originally saying, changing the defective premises, actually, you can bring action within 30 years and not 6 years of becoming aware of the breach. They were originally talking about that coming into force 2 months after the royal assent. So we'll have to see on that. But a lot of the provisions in relation to high-rise buildings and the fact that they've taken building control out of the domain of local authorities and given it to this Health and Safety Commission, a building safety regulator, you're probably looking, well, they say 12 to 18 months. There's a lot of regulations that need to be passed. So keep your eyes open.
Okay, the next one is on, as Richard will know, one of my favourite topics. It's for you, David. Will the new knotweed guidance make any difference in practice?
Probably not. The reality is that the RICS have issued guidance to surveyors setting out what their responsibilities are in relation to checking for knotweed and making it clear that they're only going to be looking for above ground evidence, so they're not going to be digging around to see if there's anything in the that's died back for the winter, and that the surveyor will give the property one of 4 ratings, A or A to D, according to how, if at all, knotweed is impacting on the property. But the same guidance from the RICS does then go on to say essentially that the lender's instructions can override the RICS guidance. So if the lender's instructions say something different, then they'll have to follow it. So it really depends on whether the lenders agree with the RICS's assessment of the position and agree to instruct surveyors and valuers on that basis. But I think the general impression being formed by certainly RICS and some others is that the government, I know, have made this comment that there's been a bit of an overreaction in respect of knotweed, and they're trying to sort of rein back on it a little bit. But yeah, it's down to the individual purchaser, I presume.
They do actually say that, save in exceptional circumstances, that they don't think it affects value.
Indeed, yeah. Of the categories, A to D, only the two of them, the most serious, actually recommend any sort of retention. In some cases, the RICS are saying that even if there's knotweed on the property, they think it doesn't have any real impact on value, because unless it's actually physically causing structural damage, then it's not really an issue. But ultimately, it's down to the buyer, I suppose, as to whether individuals are happy with it.
It'd be interesting to see, because I mean, the guidance from RICS was only about 5 or 6 weeks ago, wasn't it?
It was, yeah.
But it'd be interesting to see what the mortgagees do about it.
Yeah, indeed. I think that's going to be a critical thing.
But knotweed's on its way out. Bamboo is coming.
Bamboo's coming in now. Yeah, that's the next thing. Yeah, well, I understand. One question somebody asked me, what do the Japanese do with knotweed, and the answer is, well, they eat it. Apparently, it tastes like rhubarb. So
yeah, it does.
Yeah, so knotweed crumble.
Gin that Mike knows so much about.
Yeah.
Oh yeah. I was just going to say, at some of our CPD events, we give Japanese knotweed gin out.
Oh, right.
Price, so there you go.
Well, the Japanese have got there's sort of in Japan there's predators. Is predator the right word? You know, things that eat the knotweed anyway.
Predators, yeah.
It's been a bit of a. I think RICS more or less say it's been a big overreaction, really.
Yeah.
Don't break through foundations unless there's something wrong with your foundations.
Yeah.
And there are 2 Japanese knotweed restaurants in England, to my knowledge, in Bristol and Brighton.
Okay. All right, I'm in Bristol next week. I'll look it up. Yeah.
There you go.
Let me know.
Okay. Yeah. Moving on, the next one's for you, Richard.
Mike, have we not got a live question? There's a question coming in from Sophie Ward showing on my screen.
I've got one from Zane. Let's move on to that one. What issues does the NHQB look to solve when the current new homes building warranties are not covering? Look to solve that the current new homes building warranties are not covering.
Not sure I understand that question.
Let me read that again. What issues does the?
Yeah, I can see it on screen now. But
right, okay.
I'm not sure I know what the point is. New Homes Quality Board look to solve that the current buildings warranties are not covering. I'm not entirely sure what the focus of that question is. The New Homes Quality Board is I'm assuming they're talking here about the new 2022 Code of Conduct for builders. That's completely separate from new homes warranties. The New Homes Quality Code is intended to provide additional protections to buyers in things like cooling off periods and pre-completion inspections. So it sort of doesn't really impact on new home warranties. So I'm not sure quite what the thrust of that question is.
Did you see that Zane's just added? Sorry, I was referring to the new code.
Yeah, that's what I was just referring to. Yeah, effectively, the code is the new home, the new building code is essentially for example, saying that the builders have to provide a cooling off period. So after the reservation, there's a cooling off period of 7 days, and if the client decides not to go ahead in that timescale, then they have to have their deposit returned to them in full. Obviously, that's not covered by the warranty. The warranty protects the deposit on exchange in the case of NHBC, but it also it provides protection against pressure selling and provides a sort of ombudsman service for complaints against builders because they're not following out their after sales service. So it's I mean, those rights are in addition to the rights under the warranty, but the warranty covers obviously all the structural issues. It doesn't cover snagging items, which is basically what the quality code will cover, and requires the builder to have a proper process in place to follow those up. And if the work's not done for those snagging items, for the home buyer to have the right to complain to the ombudsman to seek enforcement against the builder. So it sits alongside and provides some of the same cover, but it's not intended to replace the warranty by any means.
Okay. The next one's for you, Richard. Do solar panels require building regulations? As I have had a conveyancer on the other side denying this.
Well, there's one thing the only thing that's actually mentioned directly, expressly in building regs is the electrical wiring part P, because it's a special installation, a solar photovoltaic cell, and it'll always require self-certification by the relevant body or building regs. But I think the consensus is that if it's on your roof, then it should have, part A, which is structural safety, part B, fire safety, part C, which is freedom from moisture. So I'd want to see building regs, basically. There is a certification scheme whereby the person can basically self-certify and show up with a local authority. But I'd want to see building regs. I remember seeing one, actually, I'm not sure if I mentioned this in the video, where it was in Yorkshire, and they'd installed solar panels on the roof of this building. The surveyor's report came back to say, ask your solicitor for building regs, because there was clear evidence of the roof bowing where the solar panels had been installed, and they didn't have it. And so what they were going to try to do is get a regularisation certificate from the council, and if they didn't, they weren't going to buy. And I think that's probably something like that's probably the best method of doing it.
Yeah, I mean, the issue is say it's the weight, isn't it? I mean, there are clearly the electrical points are clearly require the part P certificates, as you said, but it's can the weight take the roof take the weight of the additional structure? That's critical, isn't it? So
yeah, it's also the fire safety side of things, and that if they're not being installed correctly, there is a big fire risk.
Yeah. Absolutely.
So I'd need to see building regs, yeah. If it's a new build that get built into the roof and you've got building control for the whole house, you should be okay.
Yeah, it should be okay. Yeah.
So apparently they're finding that quite a few solar panels that have been installed on people's roofs were never connected to the electricity supply. So at least they're safe, I suppose. Yeah. But they no, because the roofer put them on and then we followed up. So you don't actually get any benefits, but you don't know because it's a new build.
Okay.
I've got several stories of that.
Very interesting. Next one's for you, David.
There's another one come up about building regulations. How best to deal with breaches in the conservation area? That's been brought up as as a live question.
Okay. Yeah. Do you want to? I haven't got that in front of me, but do you want to go ahead with that?
Richard, can you see it? Because it's on your.
Yeah. Best deal with breaches falling within the conservation area. Well, I mean, conservation area is more to do with planning. I'm not sure what the question is.
It says the building regulations indemnity insurance policy requires no contact with the local authority. Would this be sufficient to cover planning matters too in the absence of compliance? Is there a better way of dealing with this?
Well, I mean, say if the fact you're in a conservation area with one proviso is the same as any other planning breach, really.
Yeah.
so they can take enforcement action for if it's building work 4 years from becoming aware of the breach, or planning conditions 10 years. And the fact it's in a conservation area just sort of makes it well, slightly different as to what the breaches will be. The one exception is demolishing in a conservation area, which is a criminal offence.
Yeah.
And so I think if you've been demolishing in a conservation area, you've got a whole series of issues involved. One of the problems you might just have is that if they've made a profit from their criminal offence, then you might just be dealing with money laundering offence.
Yes. God, yes. Don't want to go down that route, do we?
Yeah, we don't want to talk about that. I've seen tree preservation orders where they've locked down the trees in breach of tree preservation orders, and they've had confiscation orders against them.
Yeah. But yeah, I agree. I mean, it's the breaches within a conservation area. It's the rules are the same, aren't they? It's just that different things will constitute a breach. So I suppose the answer is if it's more than 4 years ago.
From becoming aware of the breach.
From becoming aware of the breach, yeah. So is the policy the best way? God knows.
I think a policy is probably the easier way of doing it. If I think it says in the lender's handbook that if typical mortgagees speak, but if in your reasonable opinion there's no possibility of enforcement, we don't want a policy. Otherwise, policy
is probably the answer.
So an obvious breach, for your extension of being up in breach of planning or whatever for a dozen years, and that's an obvious breach, and I just get on with it.
Yeah, absolutely.
Okay. Next question's for you, David. Will the updated New Homes Code apply retrospectively?
No.
Quick one.
It will only apply to building works moving forward. So if you've got a builder that's not doing your snagging items and it was built last year, then it's not going to be covered. So no, it's only for properties moving forward once builders are registered with the new code provider.
The new Building Safety Act provisions, the rewriting of Section 1 of the Defective Premises Act, is intended to be retrospective.
Yeah.
For 30 years, you can bring action for defective building work in dwellings. I say retrospectively, if you find out about the breaches, like in 2010, you've got until 2040 to do something. I'm not sure how many builders will be in existence 30 years down the line, but that's another point.
Okay. Next one is, Richard, what is the latest on whether car parking can be an easement?
That should last for the rest of the session. But because I don't know if you knew this, David, I'm the one responsible for all this. Many years ago, when I started doing this as my main job, I was talking about some of those cases from the early 2000s on car parking and whether it can be an easement or not. And little did I know the problems I was causing. But anyway, basically, I mean, easements, you can't have easements of exclusive possession. It's something you read in the landlord textbooks from years ago, I remember. And if you're excluding somebody from the land, and if you want a property right that gives you exclusive possession, that's what an estate does. And so there have been cases that said, if no matter what you call it, even if it's in the schedule, if it's called an easement, it can't be an easement if you're parking in the same space all the time. Whereas if it's first come, first serve, it can be an easement. The more recent cases, and there hasn't been anything really for a while, so they say it's all a question of degree. So if you can be required to move around on management grounds, or you can be thrown out your space temporarily when the landlord tarmacs the whole area and the likes, then that can be an easement, and that's the latest. The problem if it's not an easement and it's an allocated space and it's not demised to you, let's assume it's a lease, is that it wouldn't be a property right and it wouldn't bind third-party purchasers of the reversion. It tends to be some of the older ones that tend to cause the problems, from leases from the 90s and early 2000s before anybody had ever heard of the problem. But I'm still seeing it in new builds. an allocated space and exclusive possession and an easement to park.
Yeah, there was a case in involving a property in Windsor, I think, which was I've forgotten the name of the case now, but it was that was suggesting that you can have an easement to park, but yeah, it's a can of worms, isn't it, as you say?
Yeah, it tends to be. I mean, if most modern developments would say, well, not just modern, would say that you can move around on management grounds, or try to move around on management grounds, I'd accept that as an easement. It's where that's your allocated space, full stop. That's where the problem is.
Indeed, yeah.
So another one for a policy.
Indeed.
Okay, David, for you, the next one. If I'm acting for a buyer of a listed building, should I insist that the seller provides an EPC?
Okay. Well, there's the general assumption. I'm perhaps generalizing here, but I get the impression the general assumption is that listed buildings do not require an EPC. That's actually not true. They may not require an EPC, but they're exempt from the requirements for an EPC only to the extent that requiring with an EPC requirements would contradict its listed building status. So, for example, if the EPC would say you need to rip out those drafty sash windows and replace them with shiny new PVC windows, then you don't require an EPC because the requirements or the suggestions would contradict the listed status. But we are in this rather bizarre position where individual sellers, according to the government guidance, are required to carry out an assessment beforehand to determine whether or not an EPC would recommend works which would contradict the listed status. So you almost need a pre-EPC certificate in order to determine whether you need an EPC. It's a bit of a nightmare. So I think the answer is probably not, because it's the seller's responsibility to have carried out that pre-assessment. It's a tricky one. I mean, let's be brutally honest. Does anybody pay any attention to the EPC anyway? Perhaps I don't know.
Try to let.
Well, possibly. Yeah, I suppose that's the only merit on them, isn't it? But yeah, I mean, difficult, isn't it? Difficult to know. But I think the answer is probably no. I don't think you can insist. I mean, there's a question of degrees, isn't it? Looking at an EPC on a 16th century cottage is almost certainly going to come up with recommendations that would improve the heating or improve the insulation or whatever. But those works themselves would probably not be permitted because it would contravene the listed status of the building. So there's not a clear-cut answer to that one, to be honest.
Yeah, I mean, every estate agent will tell you it doesn't need an EPC.
Yeah, indeed. Yeah, because
but if you were to have, like you say, it's just ridiculous that you almost have to have you don't know whether the recommendation report is going to not comply with the listed building status unless you've had
it. But yeah, estate agents know best. Of course, we all know that, don't we? So.
When I lived in Bath, I used to live in a Grade 1 listed building. Never again. And it was from the days pre-2013, when basically listed buildings changed, and it did have an EPC. And the EPC, the recommendation report said I could make it a higher rating by putting in cavity wall insulation. And I spent several years trying to find the cavity, but it was solid limestone.
Yeah.
Yeah, so there you go.
You should have appointed a surveyor.
Well, I did hit on the idea I could put stone cladding on, and then the cavity, and then the original Georgian facade, but I don't think the council would like that much. Yeah. Okay,
moving on. Richard, the next one's for you. Can you reconcile the cases of Vass versus Linden Mews and Gore versus Naheed?
Yeah, I think it's Das and Linden Mews.
Das,
they're both about sort of extending the dominant tenement and whether you still got the benefit of the easement. And Gore and Naheed is the more recent one. There's been another one, Parker and Roberts, which is quite significant from 2019. That is in the notes, I remember. Yeah, if you extend your land, basically, and does the extended part, it's Harrison Flower is the case from 1984, does the extended part have the benefit of all the easements? And the answer is not necessarily. What subsequent cases basically said that if the extension is ancillary, if it's sort of ancillary purpose, you still have your easements. They were both about car parking, both cases. And they basically said that the original residential house in Das and Linden Mews was not ancillary to the car parking spaces, but the car parking spaces in Gore and Naheed were ancillary to the original residential house. So that's it. That's, if that makes sense. You extend your garden, you've still got easements to get to the extended part of the garden. If you convert it to car parking, you can drive there. But if you buy the car parking and don't make it quite clear it's for the benefit of the house, the original house, then you might have problems.
Okay. David, next one's for you. If a client survey suggests that the windows in a listed building have been changed and the local search refers to a fencer certificate, what should I do?
Interesting one. Replacing windows in a listed building is may or may not require listed building consent, or it may do, depends on the nature of the work that's been done. But for example, you may not need permission to replace the glass in a sort of a standard, but if it's a particular form of aged glass, then you would probably need permission to replace it with like for like. But if it's got a fencer certificate, that rather suggests, I mean, it depends what it is. If coming back to the point I made before, wasn't it, that if they've taken out the original windows and replaced them with white UPVC windows, which have got a fencer certificate, then quite clearly there's an issue, isn't there? And that they're unlikely to have got a listed building consent to do that. And it's a question of looking into it and say, well, have they had listed building consent to replace those windows? If not, then you need to be making your client aware that the powers of enforcement for listed buildings are somewhat more draconian than they are for other buildings. So if it refers to a fencer certificate, I think I personally would be on the defensive to say that this warrants substantial investigation. What exactly has been changed? Has consent been given to it or not? So have a look at your local search. If your local search shows that it's got listed building consent, fine. If your local search doesn't mention listed building consent, I think you should be making further inquiries, or you're suggesting your client make further inquiries of the surveyor to find out what exactly has been done. And what the replacement, whether the windows were replaced with something which is meeting all the requirements of listed buildings. So has it changed the character of the building or impacted on its appearance?
Yeah, I think people get confused between planning permission and building regulations and listed building consent. I've seen enormous examples of people who, think if you get planning permission, you've got listed building consent as well, and vice versa. You need both of them quite separately building regs. Yeah. The classic is loft conversions. Because conservation areas aside, lots of loft conversions don't need planning permission, but they do need building regs if they're going to be edgewood.
Yep. Listed, but what listing is, it can cover all sorts of things. I mean, it covers the interior as well as the exterior of the building. So so you need to be having a look at what's been done. You can go a bit further. I mean, it can cover. It can even cover modern additions if it's within what's known as the curtilage of the building, and that's again, I did cover that in the notes. So you can't just assume that because you've done some work internally, it wouldn't be impacted. I mean, I did have a client once who was buying a listed building and wanted to put an ensuite shower, and the listed building officer refused consent on the grounds that it wasn't consistent with the nature of the use of the building when it was constructed. I think my client pointed out to the listing officer that when the building was constructed, they didn't have indoor toilets. So did he suggest that perhaps he should rip out the indoor toilets as well? But it's a tricky one.
I've seen them when I was in Bath. I've seen people in regular places just strip out the whole staircases and things like this on listed buildings. Yeah. Then no one gets to know until you come to act on a purchase.
Indeed.
And not with building consent for any of it.
Yeah.
Knocking down the fireplace.
Yeah.
You know, some special architectural significance to this particular fireplace, and then they've demolished it. It's probably worth a fortune as well.
Yeah, could be. Yeah, could be. I mean, it's listed it can be a nightmare. I mean, there's as I think I mentioned in the notes, there's argument recently that something that is freestanding could be listed. There was the plinths. I think I mentioned the case where the court said that freestanding urns on the top of a plinth were treated as within the curtilage and were therefore included in the listing, even though they were brought into the building by a subsequent owner who bought the property after it had been listed. And by putting them on the ground, they then became part of the listing. And when somebody subsequently took them away and sold them at auction, they were in breach of the listed building requirements because of failing to get planning permission to remove these items and sell them, even though they were not. They were in the garden and they were sort of decorative urns rather than a part of the building. So it's a bit of a minefield.
Okay. Next one's for you, Richard. How can I find out if neighbouring premises have a right to light?
Well, that should take a long time. I don't think it's necessarily your job to find out. I think it's surveyors and valuers should be spotting these things. I mean, as I mentioned, the background is that, I mean, unlike a lot of easements, the vast majority of rights to light, you're entitled to rights to light through a defined aperture, a window to you and I. And the vast majority are not expressly created, they're through prescription. And historically, it's the one that the land registry will accept after 20 years. User, unless adjoined by written agreements, you got prescriptive rights to light, and they could stop developments nearby. If I was talking about a big development, and something I'm actually doing in the commercial property course here next week or the week after, then what you do is you employ specialists to go around looking at any buildings if you intend to develop that have been receiving light through the windows for 20 years or more, and you probably make them an offer to surrender their rights to light. Obviously, you can't do that in residential. It's probably a good job that surveyors and the likes don't spot it as much as they should, but I think it's their job to spot it. And I'll be very careful if they did point out the neighbours might have rights to light if you knew that your client intended to develop. But I don't know if you want to add anything to that, David.
No, I think that's right. I mean, the rights to light is an issue. I mean, there was a discussion I saw recently about whether there's actually a right to light to your solar panels. So if a neighbour's putting an extension up which is going to block the light to your solar panels, have you got a right to light? And I seem to recall the answer is no, you haven't.
I've seen arguments to that effect, and polytunnels is another one.
Yeah, indeed.
Because there's the Allen and Greenwood case about a greenhouse receiving light, for 20 years, and greenhouses need lots of light. And they went to court to stop somebody a neighbour putting a fence up which blocked partly the light to the greenhouse. Yep.
I mean, rights to light is a live issue, and it's for big developments. And I mean, a case in point with Mr. Abramovich, the sanctioned Mr. Abramovich, when he was planning on building a massive new stadium at Stamford Bridge, he bought up all the surrounding houses. So that he could go ahead with the development. Not that he went ahead with the development, of course, and isn't now able to. But it just shows it is a major factor in large scale development work.
It can be an issue even in the sort of smaller scale. I've seen problems with people building extensions and things and just normal residential houses. But it tends to be more of a problem obviously in the bigger developments where people make a living specialising in nothing but rise to light. But I don't think it's a lawyer's job to spot the amount of light and this kind of thing.
No.
Okay, possibly the last question to you, Richard. Clients frequently don't know whether or not they have a septic tank. How can I find this out?
Well, there's an obvious way, but lots of people don't know whether they get confused between cesspits and septic tanks. So cesspit pour in, septic tank go into the environment, and these clogesters, these packaged treatment plants, small treatment plants, the water's supposed to be so pure when it comes out you can drink it, as I mentioned in my video. Here's some of the stuff here, but I've got one in the garden. It becomes important because, not least of which, in England is a bit different than in Wales, but in England, if you've got a septic tank that drains into a watercourse as opposed to a drainage field or a treatment plant, then you should be replacing it as soon as reasonably practicable. And there's obviously residential inquiries on that, e.g. within a year. You could try to see if your client's got records of maintenance, which lots of them wouldn't have bothered with, because that'll be a way of finding out. Lots of your clients don't. Now, I personally, if they didn't know whether it's a septic tank or a treatment plant or a cesspit, and they don't know if it is a septic tank where it drains, I'd want somebody to pay for a specialist drainage report.
Yeah.
And if it needs to be replaced because it goes into a watercourse, I'd deal with it in the contract, who pays for it, because they can be very, very expensive.
Certainly, I mean, it's rather hard to think, how does a client know that they're not draining into the mains? Well, I think there might be a clue on their water bill, I suppose, as well. But it's I think the issue is probably that people may not realise the difference between a cesspit and a septic tank. They get
it the wrong way around. I mean, it's sort of, it doesn't sound as if it should be that way around, and they certainly don't know whether it drains into a watercourse or a drainage field. Yeah,
of course. We've got the issues now. If it requires replacement, as you say, it must. It's an expensive operation, particularly if it drains into a watercourse, because you then got a sewage treatment plant effectively. You need environment agency licenses and all sorts of things.
I've seen £50,000.
Yeah.
So you need to deal with it in the contract, really. Who pays for it?
Well, unfortunately, that's all we have time for today. So thank you for attending LAW2022 Online, Residential Property Spring, Shape the Debate. Don't forget to join the Solicitors Group LAW2022 Online community on LinkedIn to continue the debate after the live session, and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be available on the website within the next few days. If you have purchased the online course, there is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. If you have not, then you can still buy the complete event, including a recording of this live session. To book, just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The exhibition is open for anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the webinar learning catalogue, worth £35 plus VAT. Finally, the feedback form for this course is found on the related links section, and by completing and submitting this, you will receive your CPD certificate via email. So just the final word to say thank you again and have a great day. Thank you.
Thanks.
Thank you.
Hang on.